Article 14 is concerned it would be right for the reason that mere violation of this right amounts to taking away a damaging the right. It is clear that the very nature of the objectiva in Article 39, B and C is Kesavananda v. KJ, Lala 41 1 Tiltical Party 30 implicable. The only purpose which the exclusion of Article 14 will serve would be to facilitate arbitrariness, inequality in distribution, or to enable the conformant of patronage. The right under Article 14 will only be available to the person or CLHs of persons who would be entitled to receive the benefit of distribution under the law. In fact, the availability of Article 14 in respect of LTWs under TRT Article 31C would ensure distributive justice or economic justice, which without it would be thwarted. In this view of Article 31C vis plus vis as T, 14 tenoid analogy between Article 31C and Art 31A, which is to be Durton is mill conceived bectus under the latter provision, the exclusion of Art 14 was necessary to protect the subject matter of legislation permissible thereunder in respect of compensation payable to the expropriated owner. Further, in Article 31A, the exclusio of Art 14 was confined only to acquisition, etc., of the property and not to the distribution aspect, which is not the subject matter of that article. Whereas, the exclusion of Art 14 affects distribution, which is the subject matter of Article 39B and C, it cannot be presumed that Parliament, by exercising its amending power under Art 368, intended to confer a right on Parliament and the legislatures of the states to discriminate persons similarly situated or deprive them, 0 euros equal protection of laws. The objective sought will be achieved under Article 39B, and C can be achieved even if the EWAD's Article 14 is severed, pp. 540 to 544. The law under Article 31C will only operate on 11 material resources concentration of wealth and means of production. Therefore, the rights I Article 19 Dark 1 E would have no relevance and are inapplicable. 49. Insofar as Article 31(2) is concerned, Section 2 of the 25th Amendment Act has already abridged the right contained in Articles 31(2), and a further abridgment of this right authorized by Article 31C may turn out in a given case to the destruction or abrogation of that right, and it may then have to be considered in each seat ask whether a particular law provides for such an amount as would constitute an abrogation or the emasculation of the right under Article 31(2), as it stood before the Constitution, 25th Amendment, page 549-550. On the fourth element, his lordship agreed with the reasoning and conclusion of Kana. Insofar it related only to the severance of the part relating to the declaration, 550, Akdati Pathan v. Moreus, Stale of Orua, 1963, Sub 2 SCR 691, the Provincial Transport Service v. State, LNDU 1 Tria Court, 1963, 3 SCR 650, the State of Bihar vs. Maharayodhiraya Sir Kameshwar Singh Ors, 1952, SCR 889 at Mine 97, State of UPV. Dioman Upadhyaya, 1961, with SCR 14 at P34, Ujman D. T on behalf of firm T11 Akram Ram Buxvi, State of Punjab, 1963 do SCR 353, Ram Krishna Dalmia Vishri Futiche SR. Tendolkaron Onarinda Sentemaine, SCR 239, Madhya Pradesh VGC. Mandawar, 1955 ISCR 599 Balmedi's Plan. Ulchins Light and Others Vishur. Stau of Tamil Nadu Shashatvito Doestja. Sotidiri Trinag Yurel Improvement Tievust V. Baithal Rao and State of Bombay and another V. PN EDL 1 Miwamra, 1951, SCR 682. Referred to. The first part of Article 31C may be held to be intra-1 Leonard's the amending power, only if those portions of the article which makes it ultra-virat the amendi ilg power are severed from the rest of it. The portions that may have to be tevered arca. The word 0 is in consa gtnt with or takes away, or 0 and the words marticle I4, and part dealing with declaration by reason of which judicial review k ikaded. The overability of these portions is permissible in view of the 42 Supreme Court reports, 1973, sub PSCC 11 principles laid down by this court in RMD Chamar Bagwala fusion of LND 1A, In the result on the construction of Article 31C after severing the portions indicated, S3 of 25th Amendment is valid 5R7, Punis B Province V Dawat Singh Ors, 1945, 73 India Nepal's 59, 1946, FCR1 RMD Chamar Bagua UA v. the Union of India, 1957, SCR 930 in Dao. The Hindu Women's Rights to Property Act, 1941, JFCR 12, Corporation of Calcutta, v. Calcutta Tramways Coelty, 1964, 5 SCR 25, and Kamasluvar Prasad v. State of Bihar, 1962. Sub 3, SCR 369 referred to State of Madhya Pradesh v. Ranojirao Shinde Honor, 1968, 3 SCR 489, Distinguished E. On the view taken, His Lordship did not find it necessary to consider the question whether Article 31C delegates the power of amendment to the state legislatures and Parliament. pt. 537, the Constitution, 29th Amendment is valid, but whether the acts which were